So client agreed to hire you to be the listing agent for the property to rent. And for the listing for rental, usually you don't need a very long listing period. I think 2 months will do. So I'm going to change it to January and make it January 2 months. And this is in County of Los Angeles. And that's the address. The rent amount, let's say it's $14.50 per month. Security deposit, let's ask for 2 months. So that's the $2,900. Type of tenancy, we'll go for 1 year, or it can be 2 years, but we'll go for 1 year for this. Now, how much do you charge for a commission? Whether it's a 1 year or month to month. The going rate in the LA area is usually about 50 to 100% of the first month's rent, depending on how you negotiate. If you can get away with a 100% of the first month's rent, that's great. Items included in the lease, usually the fixtures and fittings attached to the premises, and the following items are personal property. Sometimes you may have like a refrigerator. Other times you may have, the sofa and the TVs. Anything that is included in the lease will be identified here. And then items excluded from lease or rentals, such as garage or carport, and that should be indicated here. Compensation, as I said, it could be in terms of a percentage of the total rent for the term, like for example, when you have like a 1 year rent or 1 year lease. But usually we express this more in terms of a dollar amount. Okay, for example, if we are going to make this a fixed term lease, we'll just go ahead and use, for example, $14.50. Okay, so 1 year or more, most landlords are okay with paying you a full month's rent for the leasing part. But I think more likely than not, most landlords will negotiate down to just half a month's rent. Okay, so that could be $725. That's just to find a tenant for the landlord. That's for the fixed term lease, and then for month to month, you can either decide a percentage or a fixed amount for your services. And your safety period is on 3B, so you can use, say, for example, a 45-day safety period. If you have additional consideration that you're receiving from the owner, that should be completed here. Okay. If not, just leave it blank. F has to do with a situation where this property had been listed by another agent, so the owner is concerned about people who had seen the property while the previous agent had the listing, and the owner does not want to pay you any commission if that particular person wind up leasing the property because the owner may have to pay commission to the previous agent. The voice is a bit low. Is that right? Okay. Well, can you hear me better now? Okay, drop. Okay, all right. Sometimes I was told it's too loud. That's why I lower my voice just a little bit. Okay. All right, let's keep going. Next, of course, we want to put the date here. Tenant payment, all brokers authorized to accept and hold for prospective tenant a deposit to be held on cash or placed in broker's trust account. You know, if it's coming to the broker's trust account, you will check this box. But if it's going to the client, for example, the tenant, if the check is being made to the owner, you might want to check this box. Okay. Most of the time, if I'm handling it, I usually have the tenant make payment to broker's trust account. But if you are handling it, you know, perhaps we need to talk about how to handle the trust funds. Key safe or lockbox, you know, you check it appropriately depending on the situation. MLS, for leases, it's really not necessary to put it on the MLS. The problem with putting on the MLS is that you have to split your commission with the tenant's agent. That's why, you know, usually we don't put it on the MLS. We just basically list it on zero. And if the agent calls us wanting to get commission for introducing a tenant, we just simply tell them we don't pay commission to the tenant's agent. Okay. So information about this listing will not be provided. So check this box. Ownership, title, and authority. Owner warrants that owner is the legal owner. Just leave it like it is, unless you have a special situation. Web-based payment disclosure. We just decide what year was the property constructed. Now, assuming that this one was constructed after 1970, I believe this property was constructed after 19, so this will be known here, will not constructed by. Okay. And then the rest is your standard. If you have additional terms that you want to include in your listing agreement, this is where you put it. And you notice that all of the owner's information here, owner's name, address, and Centermac, and then the agent, my name, my license number, and my address is all here. So this is all ready to go. I've completed the listing agreement. All right. Assuming that I go ahead and do the open house and found a tenant for the owner. Before, certainly we have to do some screening on behalf of the owner. Now, another reason why, you know, although the policy might change in the future, but another reason why we don't allow Centermac agents to do property management is this. They are not trained to screen tenants. They don't know how to run credit check, and some don't even do credit check. So at Centermac, we will run credit check on prospective tenants. So it is important that you run credit check on the tenant, making sure that if the tenant has a bad credit report, certain things would have to be explained on the certain things that are on the credit report that is a derogatory record, that would have to be explained by the tenant. So it's our job to get this information in front of our client, the landlord, So, for example, if somebody has a low credit score of maybe 620, and the reason why the credit score is low because maybe there was a late payment or there was a foreclosure or short sale. These things would have to be explained by the prospective tenant, and that's information that we will keep in our folder. Another important thing about doing property management is that you have to have a good sense of who is a good tenant and who's not. And that requires a lot of experience. And so when you do your open houses, that's why you want to do your open houses and meet the tenants, meet the prospective tenant, and get a sense of what kind of persons the tenants are before you make your recommendation to the landlord. You know, you engage in conversations with the tenants. So after you have your open houses, after you have selected your tenant, you finish the screening. The tenant may have to do an application though. So, you know, there should be a rental application that should be filled out. I do not see this rental application here, but I believe they probably have a rental application. Application to rent. Let's look at that form. This is the application to rent form. You will simply hand this to the tenant, and tenant would have to complete the information for you. Notice that it has the date of birth and driver's license. It is important to insist on getting the driver's license number, date of birth. The driver's license number is not necessary for, actually it is necessary for credit check. So the social security number also is necessary to run a credit report. So actually you don't need the driver's license number, but I'm sure you need the social security number and date of birth to run credit report. Another reason for wanting the driver's license and social security number is that if the tenant defaults on the rent and you have to file an eviction, and the tenant is ultimately evicted and you get a money judgment against the tenant, if your landlord wants to enforce the money judgment, it's a lot easier to enforce money judgment against the tenant if you have the social security number versus if you do not have one. If you do not have one, then you have to spend some money to hire a private investigator to get the social security number. Okay, so it's a pretty detailed form. This is fairly typical of a credit application. You can collect a screening fee. I believe there is a legal limit. I do not remember what the legal amount is, but I think it's stated here. I think it's $44.50. It says here the screening fee may not exceed $30, adjusted annually from this year. And if you want to know what the latest number is, you know, just go online and Google it. But I think $44.50 might still be good for the maximum amount of screening fees that you can collect from the tenant. And so the tenant will sign here, and then you will sign here. So that's how the application is. Assuming that's completed, and everything checks out, tenant's good credit, and no bad history. So we are ready to sign a lease agreement with the tenant. And the lease agreement, you can use the month-to-month lease agreement. I apologize. Uh, can't seem to find that agreement right now. You can tell me what that full title of that agreement is, so I can show it to everybody. Residential lease agreement. Okay, maybe I'll just type lease agreement. You might be able to tell me what it is. Do you remember the lease agreement? Oh, right here. Okay, sorry about that. Okay, here it is. So now you're ready to sign to prepare the lease agreement for the tenant to sign. Okay, we found the tenant. Now we're going to need to input the name of the tenant here. New, select tenant one. Okay. Tenant's name is John Smith. And you can go ahead and input the tenant's email. So that's the tenant's name. So I got John Smith in here. Now I'm ready to fill out the lease agreement with the tenant. Now it is usually the listing agent's responsibility to help our landlord client fill out the residential lease or month-to-month rental agreement. It's a dual-purpose agreement, so you can use it for fixed-term lease or month-to-month. In this case, we decided to do a one-year lease. And so we will check a starting date. Let's say we have a starting date of January 1st, 2017. Okay. It starts on January 1st, 2017, and then it will terminate, because it is a one-year lease, it will terminate December 31st, 2017. And I'll put down 5 p.m. And tenant agrees to pay $1,450 per month. That is the monthly rent. Rent is usually I just use the first day of the month, unless you have a different date as the due date for the rent. But most of the time it's the first day. Here you can indicate how you want the rent to be paid, whether by personal check, money order, cashier check. You can have one or more or a particular form of payment. If you want to do direct deposit, you can do direct deposit. I'm just going to check personal check here, but decide how you want to pay it. And now, assuming that we want the check to come to Centermac, assuming that we're going to be doing the property management. But if we are not doing the property management, Then, I suppose you can ask for the client's name. You can put the landlord's name here and the home number. Some landlords don't like to give out their home number and home address. They would rather just let the agent handle it. Now, if you're handling the rent, then you're doing the property management. So if you are not, then you should not be putting your information here. Okay, so that's where I will fill out my information if I'm handling the check on behalf of the client. Okay, and then you put down, what are the hours? Between the hours of, let's say, 8:30 a.m. and 5:30 a.m. Following days, you can say Mondays to Fridays. Okay. And if there's any insufficient fund, then now if they have more than 3 times they were late or they had insufficient, I think they had like insufficient funds or there was a stop payment, then if they do it for 3 consecutive months, the landlord may require rent to be in cash for 3 months, and all future rent shall be paid by cashier check or money order. For a tenant that has a history of not of having check bounced or not doing well on the payment. And so here, I can indicate the cashier check, for example. Okay. Tenant agrees to pay security deposit. We ask for, actually, 1 month security deposit. I did say 2 months, didn't I? So 2,900. Security deposit. Remember, the legal maximum for a unfurnished is just 2 months. Moving costs, due date, moving funds due payable to, and we can use Centermac. And we can specify any of these payments. I think because there's always that concern that it may take a few days for the check to clear. So to prevent any inconvenience, it might be better that you ask them to prepare cashier's check or money order. Okay? Either one of this is good. Okay, don't use personal check because usually the payment date and the delivery, possession delivery date is so close together that you don't have time to wait for the personal check to clear. Okay? And then I'm not going to spend time filling out this, so you can do this yourself. Now let's go back to number 6, where we're going to talk about late charge and return checks. Late charge, I think 5% is good, but it really depends on the dollar amount. Usually, I don't like to use percentage. My late charge, I usually use something like $100. Remember, if your late charge is too excessive, then the law may not enforce it anyway. So I usually tell my client, don't put too much money. I think $100 to perhaps $200 might be. And then the 5 days is the standard grace period that we give the tenant. Okay. Parking is permitted as follows. The right to parking, now sometimes it's included in the rent and other times it's not. If it is included in the rent, you will indicate here, yes. Some of these are condominium. Now this particular one is a condominium. It probably has some parking space anyway, so it's included in the rent. Okay, so this is really attached garage. Parking is not included as extra. Just go ahead and put down a dollar amount for parking. If parking is not permitted on the premises, you can go ahead and omit that. Storage is permitted. If you don't have extra storage space, then you will skip this. But if there is a storage space included in the rent, you want to go ahead and indicate that. So the right to separate storage space, I'll just put it's not included because I don't have any extra storage space for property. And then this one says, except for personal property contained entirely within storage is not permitted on the premises. This might be the more appropriate one because this is a condominium. There are rules and restrictions for condominium, so it might be better if I check B here. If I check B here, I'm limiting the tenant to storing all of their personal properties within the premises of the property. Tenants pay utilities and the following charges. Anything that you want the tenant to pay, such as trash, you want to indicate that the tenant is paying that. But if the landlord is paying the trash, and then landscaping services, you want to put them here because this will be paid by the landlord. Okay. In certain places where it's an apartment complex where the different units are not separately metered, so in that case, then the tenant would have to tell them how much their share of the utilities are. Tenant acknowledges these items are clean and operable condition with the following exceptions. Usually, you want to check here. Tenant acknowledges the condition of the items contained in the attached statement of memo. So I think you want to check B for because you're going to do a move-in, move-out form. So most likely you can check B here. And it says here, tenant shall complete and return the memo to landlord within 3 business days after delivery. Tenant's failure to return the memo within that time shall be conclusively deemed tenant at loss for the decision. So it's definitely advantageous to check this box here because you want to make sure that the tenant delivers the completed. If they don't stand, they're deemed to be satisfied with all of the conditions of the property, such that if there are any conditions on the property that are damaged by them during the tenancy, entitled to deduct that amount from the security deposit. Tenants maintenance, use, and reporting. Here you have to decide who's going to water the garden, landscaping, and trees and shrubs. I think it's probably better if you make the tenant do it because the landlord is not going to have time to do it. Okay. And then whatever that, sometimes you may have a tenant, a landlord who has a gardener, and then he has, then the property has a sprinkler. So you may have landscaping that is to be maintained by the landlord. Well, it's low and unstable, my voice, is that right? I'll try to speak up. Okay, sorry about that. Okay. All right, so that's done. G, the following items of personal property are included in premises without warranty and landlord will not maintain, repair, or replacement. replacement. For example, dishwasher, no, washer and dryer, right? Anything else? For example, a washer and dryer is the classic one. So, we don't. Sometimes you're not required to provide washer and dryer to the landlord, but if you in fact provide them and you don't want to repair them, you might want to indicate it here. Okay. Pets allow or not allowed. No pets shall be kept. Okay. Unless you want to allow pets. If you want to allow pets, then you have the pet addendum that you want to attach to the lease agreement. No smoking. Yes. Good idea to check no smoking here. Right. With marijuana being legalized in California now, that's something landlord has to be concerned about. But don't allow them to smoke on premises. Rules and regulations. For example, if you rent a condominium, your association is going to require that you provide the condominium's rules and regulations to the tenants. If that's the case, you're going to need to provide the tenant with copies of the rules and regulations. Or sometimes by the time they sign this, you've already provided. I think the number 2 is more likely to be the case here. You can send them a link to the association's website regarding all the rules and regulations, and then also give them a copy of the rules and regulations, which you're required to do anyway. But I think this one here, it looks like is landlord's own rules and regulations. It's not the number 16. Number 16 is the one that I was talking about. That's the association's rules and regulations. If you don't have any, you don't have to check it. Many of these landlords don't have their own rules and regulations anyway. More likely it will be number 16. Okay? And then you put down the name of the association, Pepper Street HOA, for example. And then you check number 2 if you've already provided them. It's a good idea to provide them ahead of time, the rules and regulations of the HOA. In terms of keys to the premises, usually you deliver the keys to the tenant before the commencement date. So the tenant acknowledges receipt of the keys prior to commencement date, and you indicate how many keys to the premises. For example, 3 keys, and then 2 keys to the mailbox, for example. And then perhaps 1 key to the common area. And then how many remote, garage remote? Typically you have like 2 or maybe more. And tenant acknowledges the locks to the premises. You have to indicate whether it has been rekeyed or not rekeyed. So assume it has been rekeyed, so I'm just going to check this box. Next, this particular property, it was built after 1978, so I don't have to check this box. I don't have to worry about lead-based paint. Military ordnance disclosure. The property is not located within a mile of military facility, so I'm not concerned about that. But periodic pest control, if the landlord has entered into a contract with a pest control company for periodic service, this box should be checked. If not, just leave it blank. And if it has some methamphetamine contamination in the future, this should be checked. The Megan's Law is an automatic disclosure, so you don't even have to check it. So, in fact, you don't have to provide a separate disclosure for Megan's Law. Possession, you have to indicate when possession will be provided. Tenant is not in possession of the premises. If landlord is unable to deliver possession of premises on commencement date, such date shall be extended to the date on which possession is made available to tenant. If landlord is unable to deliver possession within 5 calendar days, tenant may terminate this agreement. You can change it to a different time period. Maybe you can change it to like 20 calendar days. 5 days seems a little short. Sometimes things happen. So I would just indicate, you can put 5 or 10. 5 is the default. Tenant's obligation upon vacating the premises. And here, it says, upon termination of the agreement, tenant shall give landlord all copies of all keys or opening devices to premises, including any common areas. Vacate and surrender premises to landlord empty of all persons. Vacate any and all parking and storage area. Clean and deliver the premises as in paragraph C below to landlord in the same condition as referenced in paragraph 10. Remove all debris. Give it notice to landlord of tenant's forwarding address. And whatever terms you want to include here. Okay. This is just extra term. If you don't have any, that's okay. You can leave it blank. The rest is just your standard provision. Now, the tenant always has the right to pre-move out inspection repairs, and that is to be scheduled with the property management company. And my voice is fading in and out. Are you hearing better now? You should be hearing better now.
Yes.
Okay, sounds good. Thank you so much. I appreciate it. I'm holding my iPhone very close to my mouth, so you should be hearing it very clearly now. Okay. I think it might be too loud, but if it's too loud, you tell me. These are the standard provision. Now let's look at the certain provision. Okay, now it's too loud, right? Okay, great. Okay, sorry about that. Now I'm perfect. All right, good. Okay, talking about insurance, usually it says here, tenants and guest personal property are not insured by landlord. So tenant is advised to carry tenant's own insurance or renter's insurance to protect tenant from any such loss or damage. Now, this is actually a condition. If the tenant breached this condition, I don't think it's a requirement, but it says that tenant shall comply with any requirement imposed on tenant by landlord's insurer to avoid an increase to landlord's insurance premium. Usually this is not enforced, but certainly it's a standard provision in here that advises the tenant to get insurance to protect the tenant's own properties. Okay, so as you can see, the CAR, the CAR form, is actually very comprehensive. If you use the CAR form, it basically covers every imaginable situation that you can have. So it's definitely a good form to use. Over the years, I see so many different clients. They basically do not have standard CAR form that they use for the leases. So they're missing this and they're missing that. But with the CAR form, you actually have everything that you need to have a very good lease agreement that is protective of the landlord. It's actually very protective of the landlord. Another thing that you want to put here is notices may be served at the following address or at any other location subsequently designated. Now, for the tenant, I usually just put the property address. It's a lot easier because that's where he lives, the rental property address. And the landlord, now, if the landlord does not have a property management company, then the landlord will have give an address. Sometimes the landlord can give a business address because they don't want the tenant to know where they live. But if the property is being managed by Centermac Realty, for example, then this will be Centermac Realty's address on number 36. Okay. Mediate, believe it or not, you actually have a mediation clause in the lease agreement, standard lease agreement. All this means is that if you ever get involved with a dispute with the tenant and you don't really want to file a lawsuit against the tenant, going to mediation may not be a bad thing. So that's why you have the mediation clause in here in the event there is a need to mediate. Now, bear in mind that if you don't mediate, and when you have a dispute with the tenant, and then later on you file a lawsuit with the tenant, there is something in the lease agreement that may prevent you from recovering your attorney's fees, even if you win, if you never sought to mediate before you sue your tenant. So that's something that you might want to think about. If you look at 39A, it says, it says here, landlord and tenant agree to mediate any dispute or claim arising between them out of the agreement or any resulting transaction before resulting to court action. Mediation fees, if any, shall be divided equally between the parties. And if any party commences an action without first attempting to resolve the matter to mediation or refuses to mediate after the request has been made, then the party shall not be entitled to recover attorney's fees, even if they prevail. So just keep this in mind. So before you sue your tenant, you should try to mediate dispute with them, or else you can be precluded from recovering your attorney's fees. And there is something in here that's actually quite beneficial to the landlord. It's about attorney's fees. You can actually limit the amount of attorney's fees that the tenant can recover against you should you be involved in a lawsuit against the tenant. The reason why you want to limit the amount of attorney's fees because you do not want attorneys to take up a client a tenant's case. For example, you may have a mold case, which is very typical anyway, that an attorney might not want to consider taking that mold case if they see paragraph 40, where the maximum recoverable attorney's fees is only $1,000. So it gives the attorney less incentive to take the case. So paragraph number 40 is actually a very good paragraph for landlord. When you are involved in the lawsuit against a tenant, even if you win a judgment against the tenant, most of the time you can't collect anyway. But on the other hand, if you're involved in a lawsuit with a tenant, and if the tenant wins against you, and the tenant had satisfied the mediation clause before they sued you, which means that if they win, they're entitled to recover attorney's fees against you. But if you limit them to $1,000, it can certainly limit the amount of attorney's fees that you have to pay to your tenant if you're ever involved in a lawsuit with a tenant. So definitely paragraph 40 is a great paragraph that protects our landlord. And in paragraph, so you don't have to do anything. Basically, maximum recoverable attorney's fees in any lawsuit between the tenant and the landlord is $1,000. In California, there is a requirement that if the tenant doesn't speak English and the tenant speaks one of the following languages to negotiate a lease agreement, then the tenant is entitled to have this agreement translated. Okay? So, but then sometimes you may have a tenant's relative, like a daughter or son, who actually act as an interpreter between the landlord and the parents. Then you don't need to give them a non-English lease agreement. I think you can just give them an English, this particular version of the lease agreement. But you still need the interpreter to sign the translator agreement. Okay, check this if it applies. Key safe lockbox, if you use one, make sure you check this box. Web-based pane, if you need one, check this box. Tenant, landlord in default addendum. We don't have time to discuss this particular form. There's still a lot of other forms we need to cover. I will save those for next week. Next week we'll have part 2 of today's presentation. It is quite extensive. This particular form is very extensive. There's so much to talk about. Okay, which unfortunately we don't have time to cover everything. All right, agency disclosure. Now, if the lease, do you need to provide agency disclosure if the lease is a year or less? If the lease is a year or less, do you need to provide agency disclosure? Probably not, but it's not a bad idea to provide one anyway. Okay, this is just the agency confirmation like you have on a purchase contract. So just fill out accordingly. Now remember, I told you that you don't have to represent the tenant, even if the tenant is unrepresented. You can actually have, represent the landlord exclusively. So just check this box. Okay. Leasing agent, if there is none, you don't have to fill this out. Okay. So, but then there is another form you have to fill out, which we will discuss next week on that, how to use that particular form, how to fill out that form. And if the agreement was interpreted, you have to write down the language. For example, it is like a Mandarin. So you put down Mandarin as the language that was used for the interpretation. For example, a son or a daughter interpreting for a parent. Okay. Over here we got the usual information for the tenant to fill out. I mean for the a place where you put down the tenant's name, for the tenant to sign the name, and you already got the landlord's information, and then you have your agent's information. Now this would have been should be auto-populated because you properly fill out the parties page. Okay, and then on the cooperating broker compensation. As I told you, for Centermac, we don't encourage you to put it on the MLS because it is adequate to advertise a listing through Craigslist or Zillow. Zillow is it's a very good place to put your rental or lease listing. You do not need to put it on the MLS because if you put it on the MLS, you have to split your commission with the tenant's agent. So we don't really need that because the amount of compensation is so small already. If you have to split it even further, it's really a very small amount of commission that you make from this opportunity. But sometimes you take a property, you take a listing like this to maintain relationship with the client. So it becomes a necessity than it is to really make money. It's out of professional business necessity to do a listing like this. Okay, that pretty much concludes today's training. Next week, there'll be more documents. As you can see, there's a bunch of other documents that we want to go through. And we will continue with today's training on next week. So next week will be session 2 of property management training. Okay, that concludes today's meeting, and thank you so much for attending.